What is the foreclosure process? What do you need to watch for if you're someone who's in that position? What is it that you can do to help yourself? Your state's laws set up whether you have a judicial foreclosure process or a non-judicial foreclosure process. Or said another way, whether or not your mortgage holder needs to go through the court system to foreclose on your property. If you're in a non-judicial state, what that means is that the court is not involved in the process and that the mortgage holder has the right to foreclose after certain conditions are met, the main one being the default or the failure to pay. What it looks like process-wise is that when a borrower is 60 to 90 days late, depending on the state, you end up on what's called the notice of default list, or the list pendens. At that point, the lender sends a letter to the borrower notifying them that they're 60 to 90 days late and that the borrower, or rather the lender, is initiating the foreclosure process. Then, 90 to 120 days after your default, the lender sends a notice of sale for a sale date that they set. The sale is generally set 150 to 210 days after the default. In some states, between the point of sale until a certain period of time after the sale or auction, you have what's called the right of redemption, which basically means that the borrower can come up with the money or some financing, and if you pay the outstanding balance, you can reclaim the property. Now, in today's day and age, this is pretty difficult, given all the restrictions on the ability to get financing generally right now. The redemption period is not in all states that are non-judicial, and it's not in all states that are judicial, but it does exist. Now finally, after the sale, there will be a notice that you will receive that you have 30 days to move or you face eviction. And all told, that's the non-judicial process. Now, the judicial process begins with the borrower missing the payments. Once the borrower is 90 days late, the lender will file a list pendens with the court. The list pendens is actually a notice to the public that a suit has been filed against the individual, in this case related to the foreclosure. That's followed by a reinstatement period. Now within this reinstatement period, it varies from state to state how long this will last, but the debtor at that point, during that period, can bring current the mortgage and pay any fees to resume the mortgage. Now the court gets heavily involved in the process, which is why it's called the judicial process. The complaint has been filed against the owner. And then the complaint gets served on the owner, usually by mail, sometimes in person. If it's in person, it's usually by the sheriff coming to your door and giving it to somebody who's there. Once that happens, then the owner has the opportunity to answer the complaint, which means filing papers with the court and contesting it. If the owner doesn't answer the complaint very quickly, the court will enter what's called a default judgment against the owner. And the default judgment is just that the owner has failed to respond, and therefore the court is going to assume that the case has merit, and they're going to go ahead and award judgment to the lender and against the owner. Now, some people ask, can you represent yourself? Well, I've seen both things happen. As an attorney, I would be remiss if I didn't tell you you should see an attorney. In fact, with anything we're saying, as we've said before, and we'll say it again at the end of this presentation and on our site, you should consult with an attorney to really understand the ins and outs of the laws within your state and to get advice on them. Having said that, it is possible for somebody to answer the complaint on their own. People often will show up with whatever documentation they think is useful. The likelihood of that making a difference is pretty slim most of the time, unless there's something their lawyer was able to ferret out. Assuming that they actually did file a response to the complaint, and the judge thinks there is something in contention, then there will be a discovery period. A discovery period is what it sounds like. It's an opportunity for both sides to discover information from the opposing side. Everything from mortgage policies, origination policies, the original documentation, and supporting documents. Basically, they're looking for any problems with the way that the mortgage was put together and originated, and any activity that happened along the way that might make a claim or defense for the owner against the mortgage holder that would prevent the foreclosure from going through. Again, the likelihood of finding something like that is pretty slim, and the reality is that the discovery period is just going to be a time for them to file paperwork back and forth and answer a bunch of questions. And once discovery is over, there will be a court trial date set. And then that trial will actually happen, and there'll be the usual things, somewhat like what you see on TV. But those TV shows are never quite accurate. There will be witnesses, the judge will make a determination, and then will issue a judgment. Again, a high percentage of the time, the judgment will be a judgment of foreclosure and not dismissal of the case. Once that judgment of foreclosure is entered, that reinstatement period, the time that you had to bring your mortgage current by paying fees and past due payments, will end. Now the mortgage holder no longer has an obligation to reinstate the loan if you pay all the back fees and court costs. And realistically, by that point in time, there's going to be all the court and attorney's fees. It's going to make it pretty difficult, if not impossible, for anybody to do that. Once the lender has the judgment in hand, the next step is the mortgage holder will make a motion for the foreclosure sale date, an auction date to be set. And once that date is set, they'll give you your notice sent out to the borrower saying this is the date of your foreclosure sale. And it'll be anywhere from 45 to 60 days out from the date of judgment. You can find this date out from the bank's attorney's office if you didn't receive the paperwork or you lost it. Again, if you have an attorney, you should be having your attorney make any sort of contact. You should not be contacting them directly. That would remove the protection you have from having an attorney in the first place. Once the foreclosure judgment is set, then generally you enter the redemption period. The period begins either the day of judgment or the day of sale, depending on your state. In some states, there's a special right of redemption that lasts for about 30 days after the sale, in most places I'm aware of. But for the most part, the real estate redemption period is post-judgment and pre-sale. Then there is the actual auction. And our experience says that about 1% of the properties that actually go to auction is purchased by somebody, some third party at the auction. That means that 99% of the properties that actually go to auction are taken back by the bank for the balance that they're owed. And then the bank tries to market and sell that property, which can take up to a year or more in this market, depending on where they're pricing it, the quality, condition of the property, the location of the property, and how much of a loss the bank is willing to take. However much of that loss they take, that leaves them with a deficiency or a difference between that loan balance and the price of sale. The lender actually has the right to sue the borrower for the full amount of the deficiency, including all of their attorney's fees and all the interest accruing throughout that entire period. Similarly, if somebody bought the property at auction for less than the balance that was due, the bank can pursue the loss there as well. Further, it's pretty common today to have a property that was highly leveraged, all the way up to 100%. And with declining housing prices, sometimes that property ends up over 100% leverage. So these deficiencies are also common, and the deficiency can be quite a large amount. In practice, a lot of the time, lenders don't actually pursue it because the amounts aren't enough to warrant the additional attorney's fees to go after them. But it is something that's possible. It's something that you authorized your lender to do when you signed your mortgage and promissory note, and unless they specifically agree not to pursue you at some point during the foreclosure process, the lender will retain that option. Finally, there are also potential tax consequences if the property is not your primary residence and the lender forgives or discounts the loan amount. The IRS will be expected to be paid because they count that as income for every investment property or second home.